Okay.
Court come to order. Probate suit is now in session with the Honorable Judge Paul Dean presiding.
Thank you. Good morning. Good morning. I call cause number 51196 in the estate of Edna Francis Panbaker on application of probating of will and letters testamentary. Mr. Martin, are you ready to proceed? And I believe you have.
Good morning, Judge. Yes, I am. I have the applicant, Suzanne Trullo. And two witnesses, James and Megan Stoddard.
James. Don't see James. I see Suzanne and Megan.
There's Megan.
Oh, okay. Suzanne, Megan, and James, I'll need you to raise your right hand and unmute yourself. All right, thank you. I'm going to swear you in. And do you solemnly swear that the testimony you will give today in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Okay. Suzanne and James, did y'all say I do? I'm sorry, I didn't hear it.
We did. Yes, we did.
Thank you. All right. Thank you. Mr. Martin, you may proceed.
Thank you, Judge. Suzanne, thank you for being here. Just before we start, would you introduce yourself to the court, please? Your full name.
My name is Suzanne Jones Citrullo.
And Ms. Citrullo, you're acquainted with Edna Panbaker, is that correct?
Yes.
And your relationship is that you're her daughter?
Yes,
And Miss Pam Baker passed away on September 16th, 2022.
yes,
That was in Houston, Harris County, Texas. Is that correct?
yes,
And at that time, she was 96 years old. Is that correct?
yes.
Okay. I would like to show you a document. Judge, is it okay if I,
Screen share? Absolutely, Mr. Martin.
thank you, Judge. Let me make sure I can get this up here. Oh. Okay, do you see a document on your screen?
Yes,
Okay, and would you identify that document for me, please?
it says last will and testament of Edna F. Panbaker.
Okay, and so I'm showing you a document dated June 25th, 2007, and it purports to be Edna Panbaker's last will and testament. To the best of your knowledge, did Miss Panbaker ever revoke this will?
No,
Okay, thank you very much. And now I'm going to show you another document. Okay, bear with me here 1 second. Okay, do you see a different document on your screen now?
I do. I do.
Okay, thank you. And would you identify that document for me, please?
It's the first codicil to last will and testament of Edna F. Panbaker.
Okay, and that document's dated February 6, 2018, is that correct?
Yes, although I can't see that.
There we go.
Oops.
There we go, right there.
Yes,
And to the best of your knowledge, did Miss Pam Baker ever revoke this codicil?
no,
Thank you. Okay, and there's a necessity for the administration of the estate, is that correct?
yes,
And after the date of the will, June 25th, 2007, were there any children born to or adopted by Miss Pam Baker?
no,
And after the date of the codicil, February 6, 2018, were there any children born to or adopted by Miss Pam Baker?
no,
Did the will name the state of Texas, a governmental agency of the state of Texas, or a charitable organization as a beneficiary?
no,
And did Miss Pam Baker, was she married at the time of her death?
no,
Did she have any marriages dissolved after the will and codicil were made?
no,
After December 2005, Miss Pam Baker never received Medicaid benefits. Is that correct?
correct.
Okay. And you understand that this will appoints you, Suzanne Citrullo, as the executor.
Yes,
As far as you know, are you qualified to serve as such and accept letters testamentary?
yes,
And being that the will doesn't name you as the independent executor, you filed a distributee's consent for an independent administration. Is that correct?
correct.
And one last thing, just to clarify, you've never been convicted of a crime involving moral turpitude. Is that correct?
That's correct.
Okay, thank you very much. Judge, I pass the witness if you have any questions.
No, I have no questions. Thank you.
Thank you, Judge. May I call the first witness?
Yes.
Oh, thank you, Judge. Thank you, Mr. Trullo. James, can you hear me?
I can hear you.
Hi there. Well, similar thing. Would you please introduce yourself to the court?
My name is James Citrullo.
And you were acquainted with Edna Panbaker, correct?
Yes,
What was your relationship?
it was her son-in-law.
Okay, son-in-law. And you understand that we're here to probate Miss Panbaker's will, is that correct?
Yes,
Okay, and since the codicil to the will was not notarized, we're seeking testimony regarding the authenticity of Miss Panbaker's handwritten signature on the codicil.
yes,
Okay. Throughout your relationship with Miss Panbaker, had you had the opportunity to become acquainted with her handwriting and signature?
yes, I have.
Would you just give us some examples of how you became acquainted with her handwriting and signature?
From checks she's written, signed, and some banking documents and some other financial documents.
Okay, so it sounds like mostly it was just financial documents.
Yes, mostly.
Okay, I'm gonna share my screen with you real quick. All right. So I'm showing you a document dated February 6th, 2018. It purports to be Mrs. Pannebaker's codicil to her last will and testament. I'm going to show you pages 1 and 2 of the codicil. Can you see that?
That's it.
Okay. And do you see a signature here?
I do.
And whose name is it on the signature?
That's Edna F. Panbaker.
And the handwriting, is that her handwriting?
That is her handwriting.
And are you confident that that's her signature?
I'm confident, yes.
Okay, thank you. Do you have any reason to suspect that signature was not?
No,
Okay, and to the best of your knowledge, did Miss Panbaker ever revoke the will or a codicil?
no.
Okay, thank you very much. Judge, do you have any questions for this witness?
No, thank you, Mr. Martin. You may
Thank you.
proceed.
Thank you, Mr. Citrilla. Ms. Stoddard, am I saying that correctly?
Yes,
Okay, thank you for being here. Would you introduce yourself to the judge?
I'm Megan Francis Stoddard.
Okay. And what is your relationship to Ms. Panbaker?
I'm her granddaughter.
And you understand that we're here to probate her will, and since the codicil to the will was not notarized, we're also seeking from you testimony regarding the authenticity of Ms. Panbaker's handwritten signature. Do you understand that?
Yes,
Okay. Being her granddaughter, throughout your relationship with your grandmother, Ms. Panbaker, had you ever had the opportunity to become acquainted with her handwriting and signature?
yes.
A similar question to James. In what way have you become acquainted or familiarized with her signature?
Also personal checks, as well as over 40 years of greeting cards and postcards and many stationery letters and such.
Okay, thank you. I'm going to share my screen also with you. Let me see here. One second here. Okay, I'm now showing you a document dated February 6th, 2018. Do you see this document on your screen?
It's not on the screen.
Oh, sorry. It must have come off. My mistake. Do you see that document on your screen?
Yes,
Okay. So I'm scrolling down here. Do you see a signature line?
yes.
And whose name is on that signature line?
Edna F. Panbaker.
And there's a signature on the signature line, correct?
Yes,
And whose name is written above that line?
Edna F. Panbaker.
And is that Edna F. Panbaker's handwriting and signature?
Yes,
Do you have any reason to believe that that is not her handwriting and signature?
no,
And to the best of your knowledge, did Edna Panbaker revoke her will or this codicil?
no.
Thank you very much for your time. Judge, I pass the witness to you.
Thank you. Okay, the court admits the original will on file. After hearing testimony, excuse me, the court finds that the will of Edna Francis Panbaker dated June 25th, 2007, and the codicil of Edna Francis Panbaker dated February 6, 2018 constitute both valid will and codicil. Further, the court finds that Suzanne Sutrello was named to serve as executor, and with the court finds the consents on file to allow Suzanne Sutrello to serve as independent executor. The will is admitted to probate, and Suzanne Sutrello is appointed independent executor. You're requesting to serve without bond, and is there a necessity for appraisers? Is this a non-taxable estate, Mr. Martin?
Yes, Judge, non-taxable.
Okay. Ms. Sutrella will serve without bond. The court waives the necessity of appraisers. Mr. and Mrs. Sutrella, thank you for your time today, and I'm so sorry for the loss of your loved one as well, Ms. Stoddard. Thank you for your time, and I'm so sorry for the loss of your grandmother.
Thank you.
Thank you, Your Honor.
Thank you. Have a good rest of your morning.
Likewise.
You're excused.
Thank you,
Thank
Judge.
Thank you.
Thank you. I call cause number 511350 in the state of. I'm sorry, I'm going to sign this order. I call cause number 511350 in the estate of Laurel E. Taylor on application of probate of wills and letters of testamentary. Mr. Meredith, are you ready to proceed?
We're present, Your Honor, and Mr. Taylor is here with us.
Mr. Taylor, if you could please unmute yourself and raise your right hand so I can swear you in. Thank you. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Mr. Meredith, you may proceed.
Thank you. Mr. Taylor, would you please introduce yourself for the court this morning?
Yep. Jonathan Bradley Taylor, son of Laura Elizabeth Taylor.
Thank you. And Mr. Taylor, is it your testimony that Miss Laurel E. Taylor passed away on March 27, 2022 in Harris County, Texas, and at that time she was 73 years of age?
That's correct.
And at the time she passed away, was she domiciled and have a fixed place of residence in Harris County?
Yes, she did.
Okay. And Mr. Taylor, is it also true that you have examined and looked over the document dated January 18, 2013, purporting to be her last will and testament?
Correct.
And is there any reason in your mind that that will was ever revoked?
It was not.
Mr. Meredith, we've lost your sound.
One second. How about now, Judge?
You're good. Mr. Taylor, you can hear? Okay, thank you. You may proceed.
Okay. Do we need to start over from the beginning, Your Honor?
No, we just lost your last question.
Okay. And Mr. Taylor, is it, let's go back to the previous question. Have you examined the document dated January 18, 2013 to be your mother's last will and testament?
Yes.
And as far as you know, was that will ever revoked?
Not as far as I know.
Your Honor, we asked the court take judicial notice that the document purporting to be the last will and testament has been submitted to the court.
The court takes judicial notice of the original will on file. Thank you.
Thank you. And Mr. Taylor, is it true that the will appoints your late father, Mr. Glenn E. Taylor III, to serve as the independent executor? However, he passed away in February of 2016. Is that correct?
That's correct.
And is it also true that the will then nominates you to serve as the successor independent executor?
That's correct.
And are you qualified and willing and able to serve in that capacity?
Yes.
After the date of the will, again, January 18, 2013, was any marriage of your mother dissolved by divorce or annulment?
No.
Were any children born to or adopted by her after that date?
No.
Does the will name a state, a governmental agency, or a charitable organization as a beneficiary?
No.
And finally, Mr. Taylor, is it true that a necessity does exist for the administration of this estate?
Yes.
Okay. Thank you for your testimony, Mr. Taylor. Your Honor, at this time, we ask that the will of Miss Laurel E. Taylor be admitted to probate and that Mr. Jonathan B. Taylor be appointed to serve as independent executor without bond or security. This is a non-taxable estate, and we do ask the appraisers be waived.
All right, after hearing testimony, the court finds the will of Laurel E. Taylor dated January 18, 2013 constitutes a valid will. Further, the court finds that Jonathan B. Taylor was named in the will to serve as independent executor. The will is admitted to probate and Jonathan B. Taylor is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. I'll sign that order now. Thank you, Mr. Taylor, for your time today, and I'm truly sorry for the loss of your mother and your father recently.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
Thank you, Mr. Meredith. You and your witness are excused. Thank you so much. I call cause number 510410 in the estate of Colleen Kitchens Hall on application of independent administration. Mr. Johnson, are you ready to proceed?
Yes, Your Honor, we are.
Okay, and I'll need your witnesses to to unmute themselves and to raise their right hand so I can swear them in.
Yes, Your Honor. And my witnesses are Tim Draper, Tom Draper, and Doris Hall.
Okay, thank you. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Yes,
Yeah.
ma'am.
Thank you. You may proceed, Mr. Johnson.
Thank you, Your Honor. At this time, I'd call Kimberly Hall Draper to testify.
Yes, sir.
Kimberly, would you introduce yourself to the court, please?
Yes, I'm Kimberly Hall Draper, daughter of Colleen Kitchens Hall.
Okay, and your mother passed on July the 30th, 2022, here in Harris County. Is that correct?
Yes, sir.
And at the time of her passing, she was 89 years of age, correct?
Yes.
And she maintained a fixed place of residence in Harris County at the time of her death. Is that true?
Yes.
All right. And to the best of your knowledge, did she die with a will?
Yes, she did.
Okay. And that will was a holographic will. Is that correct? It's in her own handwriting and signed by her, correct?
Yes, correct.
And the date is January the 22nd, 1979.
Correct.
So that's a long time ago, correct?
Yes, sir.
And how old were you at that time?
I was 9 years old.
And do you have any other brothers or sisters?
No, I do not.
You were your parents' only child, correct?
Correct.
All right. And does a necessity exist for the administration of this estate?
Yes, sir.
Although your mother's will was not self-proved, again, it was in her own handwriting and was signed by her. And at the time of the will, she had attained the age of 18 or more, correct?
Correct.
Okay, and she was of sound mind to the best of your knowledge at that time, correct?
Yes. Yes, sir.
All right, and the will does not name any governmental agency of the state or charitable organization as a devotee, does it?
No, it doesn't.
After the date of the will, no child was born or adopted by your mother, correct?
Correct.
And no marriage of your mother was ever dissolved after the date that the will was made, is that correct?
Correct.
Now, your mother's will named your father, Robert Earl Hall, to serve as independent executor, but it also named your aunt, which was your mother's sister-in-law, Doris Gwenda Hall, to serve as a substitute independent executor, correct?
Correct.
And your father, Robert Hall, is deceased, true?
True.
And Doris Gwenda Hall, your aunt, has declined to serve because of her age. Is that correct?
Correct.
And her waiver and renunciation of right to serve in favor of your mother, in favor of you, is on file. Is that correct?
Yes.
And to the best of your knowledge, has the required proof been made to admit this will to probate?
Yes, sir.
And you have never been convicted of any felony or crime of moral turpitude, have you?
Correct. No.
And so you are not disqualified by law from accepting any letters of administration or from serving as administrator of your mother's estate, are you?
No, I'm not.
All right. And Are you asking that your mother's will be admitted to probate and that you be appointed as independent administrator of her estate to serve without bond?
Yes, sir.
And this is a small estate. There's no need for appraisers, is there?
No, there's not.
Okay. And so you're asking then that the court admit the will to probate and appoint you, correct?
Correct.
You have, likewise, you were the only devotee under the will. Is that true?
Yes, sir.
And you have filed a consent for administration, for independent administration with the court, correct?
Yes.
I'll pass the witness, Your Honor.
Thank you. You have further witnesses, Mr. Johnson?
I do. At this time, I would call Ms. Doris Hall. And Doris, would you tell the court or identify yourself for the court, please?
Yes, Doris Gwenda Hall.
And were you related to Colleen?
Yes, I was her sister-in-law.
Okay, and how you've known Colleen for many, many years, correct?
Since 1963.
And you've seen her handwriting on numerous occasions, true?
That's correct.
You've seen her signature on many occasions, true?
Yeah, that's correct.
And you've looked at the will, that's the holographic will that's dated January the 22nd, 1979, correct?
Yes, sir.
And you've seen the handwriting and you've seen the signature. Is
Yes.
that true? And are you convinced that you were that the handwriting was that of your sister-in-law,
Yes.
Colleen? And that is also her signature?
Yes.
Okay. And do you have any reason to believe that this will was ever revoked for any reason?
No, sir.
Okay. I'll pass this witness, Your Honor.
Thank you, Mr. Johnson. You may proceed with your next witness.
At this time, I'd call Mr. Tom Draper. Tom, would you state your full name, please?
Thomas Edward Draper.
And are you familiar with Colleen Kitchens Hall?
I am.
And how are you familiar with her?
She was my mother-in-law
And you've known her for how long?
since 1988.
And likewise, during the time you've known her, have you had the occasion or many occasions to see her handwriting
Yes, sir.
and to see her signature?
Yes, sir.
And you have reviewed the document that purports to be her last will and testament that's dated January the 22nd, 1979. Is that correct?
I have.
And you've reviewed the handwriting and the signature, correct?
Yes, sir.
Are you convinced that is indeed her handwriting and her signature?
I am.
And do you have any reason to believe that this will was ever revoked for any reason?
No, sir, I do not.
I would pass the witness, Your Honor.
Thank you. Excuse me. Court takes judicial notice of the original will of Colleen Kitchens Hall on file. After hearing testimony, the court finds that the will of Colleen Kitchens Hall dated January 22nd, 1979 constitutes a valid will. Further, the court admits this will to probate and appoints Kimberly Hall Draper, AKA Kimberly Ann Hall, to serve as independent executor without bond, and the court waives the necessity of appraisers. To Ms. Draper and Ms. Hall, I'm so sorry for the loss of your loved one, but thank you so much for your time here today.
Thank you, Your Honor.
Thank you. Mr. Johnson. Oh, you have the next one. Okay.
Yes.
I call cause number 510622 in the estate of Robert Earl Hall on application of independent administration.
Your Honor, we're going to have the same witnesses
Okay.
in this matter.
Thank you. You may proceed, Mr. Johnson.
Your Honor, at this time, then I would call Kimberly Draper. And Kim, you've already introduced yourself to the court, so we'll just proceed. How are you related to Robert Earl Hall?
I'm his daughter.
And did your father die on August the 28th, 2022 in Pasadena, Harris County at the age of 92 years.
Yes, sir.
And again, your dad had a fixed place of residence in Harris County on the date of his death. Is that correct?
Yes.
And did your dad die with a will that was dated and signed on January the 22nd, 1979?
Yes.
Okay, and again, a necessity exists for the administration of his estate. Is that correct?
Yes, sir.
Now, your dad's will also was not self-proved, but it was a holographic will. And you believe that it was made under circumstances that make it a valid holographic will. Is that correct?
Yes, sir.
And at the time that the will was signed, your dad was over the age of 18 years of age and was and was of sound mind. Is that correct?
Yes, sir.
And that will has been filed with the court. Is that true?
Yes, sir.
And Your Honor, again, I'd ask you to take judicial notice of the will.
Thank you. The court takes judicial notice of the original will on file.
And in that will, no state governmental agency of the state or charitable organization was named as a devotee. Is that correct?
Yes, sir.
After the date of the will, no child was born or adopted by your father, correct?
Correct.
No marriage of your father was ever dissolved after that date. Is that true?
True.
And your father's will named your mother, Colleen K. Hall, to serve as independent executor, but then also named his sister, Doris Gwenda Hall, to serve as substitute independent executor. Is that correct?
Yes.
And your mother, unfortunately, is deceased. And Doris Gwenda Hall, who is your aunt, has declined to serve because of her age, correct?
Correct.
And her waiver and renunciation of right to serve in favor of you is on file with the court. Is that true?
Yes, sir.
And you are the only person named as a devotee who is still alive in your father's will. Is that correct?
Yes, sir.
The only other devotee was your mother, who has passed. True?
True.
Okay. And so you are the only distributee under the will, and you have filed a consent with the court for independent administration, and also you've agreed that you should be appointed as independent administrator. Is that correct?
Yes, sir.
And again, to the best of your knowledge, you're not disqualified from accepting letters of administration or serving in this estate, are you?
Correct. No. I'm not.
And are you asking that bond be waived and that appraisers be waived in this matter?
Yes.
Your Honor, we pass the witness,
Thank you.
and we would call Doris Hall. Miss Hall, you still there?
Yes, sir.
Okay. And just to make sure I'm correct, Robert Hall was your brother, correct?
Correct.
And you've known him all your life, basically, true?
That's true.
And you've seen his handwriting on many occasions
Yes, sir.
and his signature on many occasions. Yes. And you have seen the document that's his purported will that's dated January the 22nd, 1979. Is that correct?
That's correct.
And do you recognize that document to be completely in his handwriting?
Yes, I do.
And is that his signature on
Yes,
that
sir.
document? All righty. And you don't believe that this will has ever been revoked, do you?
No, sir.
All righty. I will pass this witness, Your Honor.
Thank you, Mr. Johnson.
And again, we would call Thomas Draper.
Yes, sir.
Tom, again, would you tell the court how you're related to Robert Earl Hall?
Earl was my father-in-law,
Okay, and you've known him for how many years?
again, since 1988.
And during those the years since then, you've had many occasions to view his handwriting. Is that correct?
Correct.
And his signature?
Yes, sir.
And have you reviewed this will, this purported will that was signed on January the 22nd, 1979?
I have.
Do you believe that this will is completely in your in Earl's handwriting?
I do.
And do you believe that that's his signature on this document?
I do.
Do you have any reason to believe that this will was ever revoked for any reason?
No, sir.
Your Honor, that's all the questions we have of this witness.
Thank you. After hearing testimony, the court finds that the will of Robert Earl Hall dated January 22nd, 1979 constitutes a valid will. Further, the court finds there is a necessity of the administration of the estate. The court grants request for independent administration and admits the estate of Robert Earl Hall to probate with letters of independent administration. The court further appoints Kimberly Ann Hall as independent administrator. You're asking that we waive the appointment of necessity of appraisers and for her to serve without bond.
Yes, Your Honor.
All right, a court allows Ms. Kimberly Ann Hall to serve without bond and waives the necessity of the appointment of appraisers.
Thank you, Your Honor.
You are welcome. And I'll sign the document. And thank you, Mr. Johnson. You are excused.
Thank you, Your Honor.
I call cause number 505597 in the estate of Beverly Schlichting Sug.
Good morning, Your Honor. It's Schlichting Sug.
That's very interesting. Okay, Ms. Graham, we will need to have your witness raise your right hand and I'll swear her in. Do you solemnly swear the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you.
All right, Ms. Choate, would you please state your name for the court?
Mona C. Choate.
And your mother is Beverly Schlichting Sug, is that correct?
Yes.
And is it true she passed away January 5th, 2022?
Yes.
Did she live in Harris County at the time of her death?
Yes.
And is it true she left a will dated September 18th, 2012?
Yes.
And have you reviewed the will that's on file with the court?
Yes.
Do you recognize that document to be your mother's last will and testament and also her signature?
Yes.
Your Honor, we ask the court to take judicial notice that the original is on file with the court.
Yes, the court takes judicial notice of the original will on file. Thank you.
Ms. Choate, is it true that the will named her husband, Lucius Duncan Sugg, and Canally Trust to be independent co-executors of her will and her estate?
Yes.
And is it true that Lucius passed away April 27, 2020?
Yes.
And is it true that Canally Trust signed a declination to serve?
Yes.
And to your knowledge, was the will ever revoked?
No.
Did she have any children born to her or adopted by her after writing this will?
No.
Did her will name a state, a government agency of the state, or a charity as a devisee?
No.
And is it true that all of the distributees have signed consent that you should serve as the independent administrator?
Yes.
And is there a need to administer Beverly's estate?
No.
Yes.
Yes.
Sorry.
Yes.
We have
Yes.
things
Yes.
to do on her
Yes.
estate.
Yes.
Okay.
Yes.
For to waive appraisers because the estate is not taxable.
Yes.
And are you asking the court to appoint you as independent administrator and to allow you to serve with letters of administration without a bond?
Yes.
And are you for any reason disqualified from serving in this capacity?
No.
I pass the witness, Your Honor.
Thank you. Is there a necessity for appraisers to be appointed or not, Ms. Graham?
No, Your Honor, it is not a taxable estate.
Okay, thank you. After hearing testimony, the court finds that the will of Beverly Schlichting Sug dated September 18, 2012 constitutes a valid will. The court finds there is a necessity of the administration of this estate and that all distributees agree to independent administration and appointment of Mona C. Choate as independent administrator. The court grants the request for independent administration and admits the estate of Beverly Schlichting Sug to probate for letters of independent administration and appoints Mona C. Choate as independent administrator to serve without bond, subject to filing the oath, and the court waives the necessity of appraisers. I'll sign your order now. Thank you, Ms. Choate, for your time today, and so sorry for the loss of your mother.
Thank you.
You're
Thank
welcome.
you, Your Honor.
You're welcome. I call cause number 511000 in the estate of Edward G. Lip on probate of will with as a monument of title. Mr. Dunham, are you ready to proceed?
I am, Your Honor, and I have my clients with me.
All right, I'll need to raise your right hand and I'll swear you in. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You may proceed, Mr. Dunham.
Thank you, Your Honor. I would begin by calling Melna Elise Knox Moriarty. Melna, would you state your name for the court?
Melna Elise Lip Knox Moriarty.
Okay, very good. And you're the daughter of Edward G. Lip, is that
Yes.
correct? Okay. And your father passed away on March 13th, 2017 in Harris County, is that right?
That is correct.
He was 90 years old when he passed?
Yes.
And obviously, and his death was more than 4 years ago, is that right?
Yes.
And you guys, you knew he had a will, and but as far as you knew, he didn't have a house, he didn't have a car, and everything. You guys were on the account, so you didn't think there was a necessity to administer the estate at the time. But recently, you've discovered there's some oil and gas interests, and they wanted you to get the will in the probate, and that's why we're doing it after 4 years.
Yeah.
Correct? Okay, very good.
Exactly.
After at the time you passed, your father was a resident of Harris County. Is that correct?
That is correct.
Okay, I'm going to show you the document. Do you recognize this as a copy of the last will and testament of your father?
It is.
Okay, very good. And it is dated September 26, 2012. Is that right?
Yes.
That's your father's signature. Is that right?
Yes.
As far as you know, did your father ever revoke this will?
No.
Okay, very good. Your Honor, we asked the court to take judicial notice of the original will. It's on file with the court.
Thank you. The court takes judicial notice of the original will on file.
Okay, and today we're just asking the court to admit the will as a monument of title. We're not asking, there's not a necessity to administer your father's estate. Is that correct?
That's correct.
Okay, very good. As far as you know, there's no debts owed by your father. Is that correct?
Nothing.
Okay, very good. And your father never applied for or received Medicaid benefits on or after March 1st, 2005, correct?
He did not.
Okay, very good. After your father signed his will, were there any children born to or adopted by him?
No.
Was he ever divorced after he made his will?
No.
Does his will provide any gifts to any charity, to the state of Texas, or to any agency of the state of Texas?
No.
Very good. Your Honor, I would pass this witness at this time. And,
Thank you.
I'll call Lyndon Thomas Lip. Lyndon, would you state your name for the court?
Lyndon Thompson.
You're the son of Edward G. Lip, is that correct?
Yes.
Okay. You've heard your sister's testimony here today. Would you agree to the answers that she gave to all the questions I've asked her?
To all the questions. Yes.
Okay, very good. Your Honor, based on testimony, we'd ask that the last will and testament of Edward G. Lip be admitted to probate as monument of title only. And since the applicants are the only devisees under the will, we'd ask that the necessity for the affidavit of compliance be waived.
Thank you. After hearing testimony, the court finds that the will of Edward G. Lip dated September 26, 2012 constitutes a valid will and that there is no necessity for the administration of this estate. The court admits the will of Edward G. Lip to probate as a monument of title only, and the court waives the affidavit of fulfillment of terms.
Thank you, Your Honor.
Thank you. I'll sign your order and thank you, Mr. and Mrs. Lip. I'm sorry, Mr. Lip and Miss Moriarty. And I'm so sorry for the loss of your father. It sounds like he lived a really long and hopefully fruitful life.
He did. He was a sweetheart.
Thank you.
Yeah,
Thank you, Your
that's
Honor.
wonderful. Thank you so much. Have a good day.
Bye-bye.
Mr. Dunham, you're excused.
Thank you, Your Honor.
Thank you. I call cause number 510964 in the estate of Virginia G. Lopez, AKA Virginia Garza Lopez, on application of probate of will and letters testamentary. Ms. Hilden, are you ready to proceed?
I am, Judge, and I'll be testifying.
Wonderful. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do, Judge. Thank you.
Thank you.
My name is Elizabeth Hilbin, and I'm the attorney for the applicant Ronald Lopez in the estate of Virginia G. Lopez, also known as Virginia Garza Lopez. Ms. Lopez passed away in Houston, Harris County, Texas, where she was domiciled on September 19th, 2022. She left her valid last will and testament, which was dated July 31st, 1985. That will was never revoked. It was self-proved. There were no children born to or adopted by her after the date of the will. There was a marriage that was dissolved. Her husband, John Lopez, passed away on September 3rd, 1989. The decedent's will did name Edward Lopez and Sylvia Lopez to serve as independent executors. However, they have filed a waiver in favor of their brother, Ronald Wayne Lopez, who is qualified to serve and not disqualified for any reason as independent executor. There's no state, charity, or governmental agency named in this will. This is a non-taxable estate, Your Honor. And I do ask the judge to take judicial notice that the original will has been filed with this court. We're asking that the will be admitted to probate, that Ronald Wayne Lopez be appointed as the independent executor without bond. And since this is a non-taxable estate, judge, that the appraisers be waived. Appointment. That's all I have.
Thank you. The court takes judicial notice of the original will on file. After hearing testimony, the court finds that the will of Virginia G. Lopez, dated July 31st, 1985, constitutes a valid will. Further, the court finds that Ronald Wayne Lopez was named in the will to serve as independent executor. The will is admitted to probate, and Ronald Wayne Lopez is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. Thank you, Ms. Hillman, for your time today.
Thank you, Judge.
You're welcome. I call cause number 511418 in the estate of Guy Edward Matthews on application of probate of will and letters testamentary. Mr. Hall, are you ready to proceed?
I am, Your Honor, and I'm the only witness, so I need to be sworn in.
Okay. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you, Mr. Hall. You may proceed.
My name is Russell W. Hall. I was well acquainted with Guy Edward Matthews, the decedent. He died on November 23rd, 2022 in Harris County, Texas, at the age of 84. The date of his death was less than 4 years ago. He was a resident of Harris County at the time of his death. Your Honor, if you had noticed the original will, I've reviewed it, and it's dated December 30th, 2021. To the best of my knowledge, the decedent never revoked this will. There is a necessity for administration. After the date of the will, no children were born to or adopted by Mr. Matthews. He was never divorced. The will does not name the state of Texas, a governmental agency of the state, or a charitable organization as a devisee. Carolyn Burgess Matthews has asked the court to appoint her as executor of this estate. She's qualified to serve as such and to accept letters testamentary. Your Honor, we don't know if this estate's taxable yet or not. However, I'd ask the court notice that no interested person has applied for the appointment of appraisers. We ask that Carolyn Burgess Matthews be appointed independent executor to serve without bond. And we ask the court to find that there's no need for court appointment of an appraiser.
Thank you. The court takes judicial notice of the original will on file. After hearing testimony, the court finds that the will of Guy Edwards Matthew, dated December 30th, 2021, constitutes a valid will. Further, the court finds that Carolyn Burgess Matthews was named in the will to serve as independent executor. The will is admitted to probate, and Carolyn Burgess Matthews is appointed independent executor to serve without bond, and the court waives the necessity of appraisers.
Thank you, Your Honor, and welcome to the bench.
Thank you, Mr. Hall. I will sign your order currently.
May I be excused?
Yes, Mr. Hall, you may be excused. Have a great day.
Thank you, you too.
I call cause number 511152 in the estate of Lynn McBee, aka Marilyn Roslyn Meisel. Ms. Weissenthal?
Yes, that's me. And I am the witness.
Okay. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, my name is Kathleen Wiesenthal, and I am personally acquainted with Lynn McBee, AKA Marilyn Rosalind Mizell. She died on October 23rd of 2022 in Bel Air, Harris County, at the age of 88 years, and it has now been 4 years since her death. She did have a fixed place of residence in Harris County on the date of her death. She died with a will that I would ask the court to take judicial notice that the court has the original will.
Court takes judicial notice of the original will on file.
Thank you. And that will was signed on May 21st of 2019. There is a necessity for the administration of her estate. Her will was self-proved, and to the best of my knowledge, it was not revoked by the decedent before her death. No state governmental agency or charitable organization is named in the will as a devicee, and after the date of the will, no child was born to or adopted by decedent. No marriage was ever dissolved. She was unmarried at the time of her death, and she named Kathleen Wiesenthal to serve as independent executor to act independently without bond. And to the best of my knowledge, I am not disqualified by law from accepting the letters testamentary, and I am entitled to those letters, and I am the person named in her will. This is not a taxable estate, so I would ask the court to waive the appointing of appraisers.
Okay, thank you. After hearing testimony, the court finds that the will of Lynn McBee, AKA Marilyn Rosalind Mizell, dated May 21st, 2019, constitutes a valid will. Further, the court finds that, Kathleen Wiesenthal was named to serve as independent executor. The will is admitted to probate, and Kathleen Wiesenthal is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. Thank you, Ms. Wiesenthal. I'm so sorry for the loss of your loved one.
Thank you. Thank you, Your Honor.
Have a good day, and I'm signing the order now.
Thank you, Your Honor. Goodbye.
Bye-bye. You are excused. I call calls number 511171 on the estate of Ronald Lawrence Hocab on application of probate of will and letters of testamentary. Ms. Lumpkin, are you ready to proceed?
Good morning, Your Honor. Yes, I'll be testifying today.
So raise your hand. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
My name is Catherine Lumpkin, and I am here today on behalf of Anita Gerchak Kokab, the wife of the decedent. Ronald Lawrence Kokab died on October 31st, 2022 in Humble, Harris County, Texas at the age of 83, and 4 years have not elapsed since the time of his death. Decedent had a fixed place of residence in Harris County at the time of his passing. The decedent left a valid written will dated March 27th, 2018, and insofar as I know or believe, this will was never modified or revoked. I request that the court take judicial notice that the original is on file with the court.
The court takes judicial notice of the original will on file. Thank you.
A necessity exists for the administration of this estate. After the date of the will, no child was born to or adopted by the decedent, and no marriage of the decedent was dissolved after the will was made. Decedent's will names his wife, Anita Gerchak Kokab, as the independent executor to act independently without bond or other security, and she is qualified and not disqualified from serving. No state governmental agency of this state or charitable organization is named by the will in the will as a devizee. And this is a non-taxable estate. We're asking the court to waive the appointment of appraisers.
Thank you. After hearing testimony, the court finds the will of Ronald Lawrence Kokab dated March 27, 2018 constitutes a valid will. Further, the court finds that Anita Gerchak Kokab was named in the will to serve as independent executor. The will is admitted to probate, and Anita Gerchak Kokab is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. And I'll sign the order. Thank you so much. Ms.
Thank you, Your
Lumpkin,
Honor. Thank you.
have a good rest of your day. Thank you.
too.
I call cause number 511536 in the estate of Roger Wallace Dart on application of probate will letters testamentary. Thank you, Ms. McKellen Lissy. Good morning. I'll need to swear in Ms. Dart. If you'll raise your right hand. Thank you. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed, Ms. Lissy.
Ms. Dart, can you please state your full name for the record? My name is Kathleen Ann Dart. And how are you associated with the decedent? I'm his wife. And did your husband die on August 22nd, 2022 in Harris County, Texas? Yes. And at the time of his death, your husband was 81 years old? Yes. More than 4 years have not elapsed since the date of your husband's death? True. To the best of your knowledge, your husband left a last will and testament dated May 28th, 1993? That's true. And the original is on file with the court? Yes. And to the best of your knowledge, the will was never revoked? Yes. There is a necessity for administration of this estate? Say that again. There's a necessity for administration? Yes, yes. And your husband's will was self-proved? Yes. And no state governmental agency or charitable organization is named as a devisee of the will? True. And after the date of the will, no child was born to or adopted by the decedent? True. And no marriage of the decedent was dissolved after the making of the will? No. And true. That's true. Okay. Yeah, that's true. And you were named as independent executor to serve without bond, correct? True. And you are qualified and not disqualified from serving as independent executor. True. Yes. Your Honor, we're asking that you admit the will to probate and appoint Ms. Dart as executor. This is not a taxable estate. So we're asking you waive appraisers.
All right. Thank you so much, Ms. Dart, for your time here today. And I'm so sorry for the loss of your husband.
Thank you.
You're welcome. After hearing testimony, the court finds the will of Roger Wallace Dart constitutes a valid will. Further, the court finds that Kathleen Ann Dart was named in the will to serve as independent executor. The will is admitted to probate, and Kathleen Ann Dart is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. And I'll sign your order.
Thank you, Judge. May we be excused?
Yes, Ms. Leslie, thank you so much for your time as well. And yes, you may be excused. Have a great day. I call cause number 510890 in the estate of Gandy Oren Pillows, aka Gandy Oren Pillows, aka GO Pillows, aka Gandy Pillows. This is on an application of probate of will and letters testamentary. Ms. Creel, are you ready to proceed?
Yes, Judge.
I'll be testifying. Okay. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may proceed.
Good morning. The decedent, Gandy Oren Pillows, and all the AKAs died on August 21st, 2022 in Houston, Harris County, Texas at the age of 90 years. He was a resident of Harris County at the time of his death. He died without revoking the will dated December 14th, 2021. And Judge, I would ask that you take judicial notice that the original is on file with the court.
The court takes judicial notice of the original will on file. Thank you.
There is a necessity for the administration of the estate. The decedent did not have any marriages dissolved after the making of the will. There were no children born or adopted by the decedent after the making of the will. The will does not name a state, government agency, or charitable organization as a devisee in the will. The will did name Lizolette Pillows to serve as independent executor. However, she died on September 13th, 2022. In the alternative, the will named Eric R. Potts to serve as independent executor. He is qualified to serve. This is a non-taxable estate, and I would ask that appraisers be waived.
Thank you, Ms. Creel. After hearing testimony, the court finds that the will of Brandy Orrin Pillows dated December 14, 2021 constitutes a valid will. Further, the court finds that Eric R. Potts was named in the will to serve as independent executor. The will is admitted to probate and Eric R. Potts is appointed independent executor to serve without bond, and the court waives the necessity of appraiser. Thank you so much, Ms. Creel. You may be excused. I call cause number 513088 in the estate of Betty Ann Burnell on application of probate of wills and letters of testamentary. Mr. Cooper, are you ready to proceed?
I am, and I'll be giving testimony today, Your Honor.
Thank you. All right, if you'll raise your right hand. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You may proceed.
Your Honor, my name is Jonathan Paul Cooper, and I'm here on behalf of the applicants Ronald L. Burnell and Lisa Burnell Roasted. Betty Ann L. Burnell died on January 23rd, 2023 in the city of Houston, Harris County, Texas, at the age of 99. At the time of her death, the decedent resided and had her domicile in Harris County, Texas, and her principal property was located in Harris County. So far, it is known to me the decedent never revoked the instrument dated March 16th, 2022, purporting to be her last will and testament, such instrument having been electronically filed in the court on February 1st and the original being received on February 2nd of 2023. I ask that the court take judicial notice that the instrument filed in this proceeding is an original.
Thank you. The court takes judicial notice of the original on file.
Thank you, Your Honor. The applicants Robert L. Burnell and Lisa Burnell Roasted are entitled by law to letters testamentary for the estate of the decedent, and they are not disqualified from accepting the letters testamentary. No child was born to or adopted by the decedent after the making of her will. The decedent was predeceased by her husband, M. Lewis Burnell, on December 23rd, 2009. And no other marriage of the decedent was ever dissolved after the making of the will. The decedent did not name the state of Texas, a government agency of the state of Texas, or a charitable organization as a devisee under her will. Your Honor, at this time, we ask that the will filed in these proceedings be admitted to probate as the last will and testament of Betty Ann L. Burnell, that Robert L. Burnell and Lisa Burnell Roasted be appointed as independent co-executors to serve without bond, and that letters testamentary be issued to them, and that appraisers of the estate be waived.
Thank you, Mr. Cooper. After hearing testimony, the court finds that the will of Betty Ann Burnell constitutes a valid will. Further, the court finds that Ronald L. Burnell and Lisa Burnell Rostad were named in the will as independent co-executors. The will is admitted to probate, and Ronald L. Burnell and Lisa Burnell Rostad are appointed independent executors to serve without bond, and the court waives the necessity of appraisers. I'm signing your document now, Mr. Cooper, and you may be excused.
Thank you, Your Honor. You have a wonderful day.
You too. Thank you. I call cause number 510803 in the estate of Carmen Gail Florkey